Thanks, Jenny, hi everyone. Thanks for joining. Yeah, so I'll just open it up with a few framing remarks. We want to leave as much time for questions as possible here, but I just wanted to hit a few points, at the outset. First, and I really do think this is an important point. Today's executive order, as well as the Department of Justice regulations, which unfortunately I don't think we've seen yet, but they're very important too. So that's why I'm talking about them both together. But even without seeing them, what is really most important about the fact that we've got this executive order and Department of Justice regulations, signed and released today is that as of today, it signifies a change in U.S. law. I think a change in U.S. law for the better. We all know that that what gave rise to this was the invalidation of the Privacy Shield agreement. It'll certainly be several months before we have an adequacy decision for a new what is now called the new EU-US data privacy framework to replace that invalidated Privacy Shield framework. But it's really important to remember that adequacy is not the only tool for international transfers, and that's why it's so important that U.S. law has changed today, because it actually helps to stabilize the other data transfer mechanisms. In particular, standard contractual clauses or model clauses, which companies incorporate into their contracts, are by far the most used mechanism to transfer data from the EU. By some estimates, I think it's 90% or so of the data is transferred by those mechanisms. So it's really important that as companies are adopting the modernized standard contractual clauses that the Commission published following the Schrems II judgment, and they're implementing their data transfer impact assessments. They are able to now cite this changed U.S. law, and so it's critical. And I think that both the Commission and the U.S. government in their statements have pointed this out, that the various different safeguards that are comprised in the executive order actually, and the DOJ regs actually do help stabilize these other transfer mechanisms today. So companies are in a better place today than they were yesterday due to the issuance of these legal instruments. I think everyone's probably familiar with the key elements of the executive order and the DOJ regulations by now, so I won't spend too much time on them, and rather just leave some time for your questions. But the executive order and the DOJ regulations, they are the first phase of the implementation of the political agreement that was announced by Presidents Biden and von der Leyen back in March. We've been hearing for a while now, that we need to work out the implementation details. On the U.S. side, these are the implementation details, and I would put them in two buckets. It's the same two buckets that were identified by the Court of Justice as needing improvement in the Schrems II case. Number one, you've got binding safeguards that limit access to data by U.S. intelligence authorities to what is necessary and proportionate to protect national security interests. And then two, there's an establishment of a dual layer, independent and impartial redress mechanism, which notably includes the creation of a new data protection review court to investigate and resolve complaints regarding access to EU citizen data by U.S. national security authorities. There are certainly other pieces of the executive order and the Department of Justice regulations including that U.S. intelligence agencies are going to, review their policies and procedures to implement the safeguards, and that's going to be reviewed by the Privacy and Civil Liberties Oversight Board. But the bottom line is that these are significant improvements compared to the predecessor Privacy Shield, and that, again, these new safeguards will really complement the obligations that U.S. companies have on the commercial side of the agreement, which is largely going to remain intact as we understand it. And that's what's administered by the Department of Commerce. Finally, just wanted to also anticipate a question that I think a lot of people are asking, what's different this time? Why is, how is this going to be any different than what was agreed to in Privacy Shield? How is this going to survive a court challenge, perhaps an inevitable court challenge? I would just say a couple of things quickly. Number one, it's been pretty clear from the outset, and one of the reasons that this has taken a while is that U.S. negotiators and EU negotiators have been pretty laser focused on creating a solution that would address the failings of the Privacy Shield as addressed by the Court of Justice. And I think it's notable that today, certainly both sides of those negotiations seem to be expressing a lot of confidence that this will survive an inevitable third court challenge, if you will. So I think that's a good thing. I mean, second, for sure, I do think that there's reason to be optimistic also here that this will result in a different outcome, because, as I said at the outset, we're talking about legal changes this time, as opposed to the last time around, where we really had commitments that took the form of letters that were attached as annexes to the Privacy Shield agreement. We have actual significant legal changes this time around. So I think that also bodes well. And then finally, I'll just really quickly reference some other work that's going on in parallel for the past 2 years at the OECD regarding trusted government access to private sector data. And there you have a situation where you've got all of the various different OECD member countries, as well as the European Union. So in addition to the United States and EU member states, you've got Canada, you've got Japan, you've got Australia, you've got the UK, you've got others. And what that effort is all about is identifying all of the commonalities between the surveillance and national security regimes, including on these important topics of necessity and proportionality and redress. And I think we're hopeful that perhaps even by the end of the year, the OECD will publish what is essentially those principles that identify all those commonalities. And it'll make it clear that what the US and what the EU and what all those other democratic nations are doing in this regard is substantially the same thing. And I think that'll just be very helpful in changing the conversation as we go forward. So I will stop there. Look forward to your questions, but I will first turn it over to my colleague, Guido Lobrano. Thank you.
Thank you, John. Jenny, should I move forward?
Yeah, just a reminder to participants on the call to please put your questions in the chat or Q&A if you have any. Thanks.
Thank you, Jenny. So thanks, John, for that overview. From my side, I'd like to address more the European angle to this. So what is going to happen now? What the reactions so far are? And let me start by saying that, of course, this is the result of almost 2 years of negotiations between the European Commission and the United States government. So I think it's fair to say there were not a lot of huge surprises for the European Commission, who was part of those negotiations today. I think the primary reactions that we've seen from the Commission is a reaction that the Commission is very confident that what has been achieved today is a sound, credible solution. And to compare this situation with the one we had when Privacy Shield was annulled, I think we need to take a step back even further. When the safe harbor was annulled by the European Court of Justice, the Schrems I ruling. Schrems I annulled the framework for transferring data between the European Union and the US, but there is a big difference between that ruling and the ruling that we've seen in 2020 that actually annulled the Privacy Shield. And the difference that in that case, the court has given very clear indications of what the judges wanted the two parties to address in the future. And it's on that basis that now that these negotiations have led us to the text that we're seeing today. The court, as John also referred to earlier, talked about the weakness of the redress system, talked about the need for more proportionality, better respecting the proportionality and necessity principles. And there are all these elements in the executive order that we've seen today. As far as the redress solution is concerned, I think we'll all need to see the details in the DOJ regulations that, as John mentioned, are not available yet, but should be available shortly. But it seems like we're off to a good start. In terms of the next steps, many will probably know that already. According to the GDPR, the European Commission will now need to adopt a so-called adequacy decision. It is largely expected to be published as a draft version in 4 to 6 weeks from now, which leads us to the first half of November, following which there will be an approval process that requires a number of steps. It requires an opinion from the European Data Protection Board, which is the body that puts together the national data protection authorities, and also requires approval through a so-called comitology procedure by member states. This is a qualified majority proceeding, which means at least roughly 15 member states that represent 65% of the European population need to endorse the findings of the European Commission in the draft adequacy decision. The European Parliament also has a significant role. It has a power of scrutiny, so it can and is definitely expected to adopt a resolution where it will also address the executive order solution and issue its own views on, and it will also address the draft adequacy decision and issue views on whether they believe that is accurate and whether the Commission is actually respecting the boundaries set out by EU law by issuing that decision. The overall process will likely last around 6 months, which might lead us to somewhere in spring, March, April 2023 for a final adoption. Once the adequacy decision is adopted, that's when the framework will actually be operational, meaning companies will be able to transfer data according to the framework. This is a short overview of the process. Jenny, tell me if that's enough, if there's more details that we want to share.
I think we're okay. We have a question in the chat from Margaret Spiegelman with Inside US Trade. How difficult would it be for future administration to undo actions directed in the order? John, that one's probably better for you.
Yeah, thanks, Margaret, for the question. I mean, I assume what's kind of underlying that question is, the sufficiency of an administrative solution versus a legislative solution. I mean, to answer the question directly, while it's true that a future administration could change an administrative action, I mean, I think, in practice, that seldom happens, particularly in this area of the law dealing with national security. I mean, for instance, one of the authorities that has kind of been at the center of the Schrems decisions has been an executive order, right? Executive Order 12333, which has been on the books for, I don't know, I believe since the 1980s. Number two, I don't think it's any easier or harder to change an executive order than it is to change a law. And I think that's true in both the U.S. and the European context. For instance, the GDPR came online just in 2018, and it replaced a prior legal instrument, right? The EU Data Protection Directive. I mean, we have laws that are undone by future Congresses. I mean, so it's possible. It's always possible that could happen. But the one other thing that I would say is that there are actually very practical, pragmatic reasons why an administrative solution via an executive order to affect this legal change is probably superior to legislation. And one of the real reasons, and the reason for that involves both the competency of the president over national security matters, such as or matters involving national security, such as this, and then secondly, there are very significant issues that could be encountered with legislation from kind of a particularly with respect to for instance, trying to create legal standing or things like that. So it could be changed. I don't think it's likely. I also don't think that a future administration would be inclined to change this, because this is, I think, a benefit to everyone, to the EU, to the US, to EU and US companies. So it's possible. I don't think it's likely, and I don't think it's any harder or easier than changing legislation.
If I may add to that, John, from the European perspective, there is an additional element here, which is that the GDPR already requires any adequacy decision to be reviewed as a minimum every 4 years. Now, if we look at the UK adequacy, there was a clause for an annual review. So that it is expected that even the new draft adequacy decision that the European Commission will issue will have some sort of similar review. That means if there is any change, a relevant change into US law, it will need to be taken into account in a future adequacy decision. And obviously, the United States know that, so they need to take them into account.
Yeah, that's really a great point, Guido. Just to underscore that, I mean, we obviously, the adequacy decision is not yet drafted, as far as we know. It's probably going to be, at least several weeks, I think, but before we see that. But yeah, I would be very surprised if there wasn't a provision in that adequacy decision, both for review and probably conditioning the adequacy decision on these legal changes remaining intact, right? So I would expect that, again. I don't think there will be a lot of motivation for a future administration to change the law, particularly if it knew that it would, basically undermine the adequacy decision that we hope will be passed in the spring.
Well, John and Guido, I don't know if you have any other points to add. We don't have any more questions in the chat, so we will, like I said, we have a recording of this call. So if you have any additional questions, or if you want to view the recording again, just reach out and let me know. Otherwise, thanks so much for joining, and enjoy the rest of your day. Thank you.